Then I will go ahead and call our meeting to order. And we'll start with our minutes of the last meeting, Jim.
Okay. The Goingsnake District Heritage Association meeting was called to order by President Jack Baker at 10:11 a.m. with 20 members and guests present virtually. 84 people have viewed the YouTube video. Secretary Jim Terry read the minutes of the January 15th meeting, and they were approved as read. Jack Baker told us that Treasurer Faulkner had fallen recently and was in physical rehab. Everyone was thrilled to see Maribel Chase back with us, and she thanked everyone who sent her cards during her stay in physical rehab before giving her Cherokee Moment presentation for Black History Month. She read the Indian Pioneer paper interview of Elijah Hardwick about experiences and conditions in the new nation in Kansas of Cherokee slaves. In old business, we elected officers that had been postponed during our January meeting. Patsy Edgar made the motion that all officers except Vice President remain the same and was seconded and passed by unanimous vote. Billy Shotpouch was elected Vice President. Jack Baker, Ruth Faulkner, Treasurer, Jim Terry, Secretary, and Luke Williams will continue to serve this year. Becky Hobbs told us that things were moving forward with the possibility of a Broadway production of Nanny Yee, and a group of Los Angeles had expressed interest in a miniseries of the Nancy Ward story. In new business, Curtis Rohr announced the spring meeting of the Oklahoma Trail of Tears Association to be held at the Cherokee Casino starting at 10 a.m. Saturday, April 23rd. Our featured speaker was Dr. Brett Riggs from the Cherokee Studies Program of the Western Carolina University. He gave a very interesting presentation titled Reconstructing the Landscapes for Fort Cass and the Cherokee Immigration Depot. President Jack Baker adjourned the meeting at 11:51 a.m.
Okay, thanks, Jim. Are there any additions or corrections? If not, I would entertain a motion that the minutes be approved as given.
I so move.
Is there a second?
Second.
Okay. All those in favor of approving the minutes signify by saying aye. Or thumbs up. Okay. Any opposed? The minutes are approved. Thanks, Jim. And we did get a treasurer's report from Ruth, did we?
I didn't.
No, and I didn't either, so, okay. Then we will move forward and we will have our Cherokee Moments from Maribel.
Good morning, everyone. My Cherokee Moments for this morning is public school system in the Cherokee Nation. Chief John Ross, who was committed to the goals of independence and prosperity for the Cherokee people, believed that their security lay in their education. In his annual message to the Cherokee legislature in the fall of 1840, Chief Ross recommended that they come up with a plan for a free public school system. Of course, during this time, there were missionary schools that many Cherokee children attended, but Chief Ross asked for no help from the missionaries or from the U.S. government. The Public Education Act of 1841 called for the appointment of a national superintendent of schools, excuse me, to be paid from the national treasury, and he was to supervise the school system. In each community where a school was located, the people were required to elect 3 local school directors, whose duty was to see that the community built and maintained a school building. The schools buildings were built of logs by the Cherokee people themselves in each district. In the beginning, most of the teachers were white people who were from the East, and they were paid accordingly to what the pay was in the East. As more Cherokees became educated, many of them took over as teachers, replacing the whites. The superintendent selected the teacher of each school with the advice of the three directors. Schools were to have a minimum of 25 students who lived within walking distance. If the local directors could not maintain this number, the superintendent had the right to move the school to a more populated location in the district. Immediately, there were some problems. The full-blood Cherokees saw no need for education, while the mixed bloods were accepting of the Cherokee school system. The Cherokee-speaking children of full-blood parents found it difficult to learn from teachers who did not speak Cherokee. In 1843, the council increased the number of schools from 8 to 18. In 1846, 3 more schools were added. By 1860, there were 30 public schools in the nation. An editorial in the Cherokee Advocate on March the 7th, 1874, stated that, quote, "We now have 67 common schools at an average expense of $400 each, and with a total school population of 1,800 out of perhaps 3,600 school-aged children. The average is not more than 15 pupils in attendance at each school. There are at least 20 schools in the full-blood areas which will not average over 5 students," end of quotes. The editor of the Advocate believed that the costs needed to be re-evaluated and that some of the system needed to be overhauled. He believed that the full-blood children must have a knowledge of the English language and should have textbooks in the English language with definitions in the Cherokee language. At any rate, even with some of the problems they had at hand, the schools flourished, and out of the public school system and the missionary schools and the male and female seminaries came future citizens and leaders of the Cherokee Nation. This was due to the vision of Chief John Ross and other leaders who saw the need for the education for the Cherokee people so that they would be able to take their place in the world. The school records for the Cherokee Nation before statehood can be researched at the History Center in Oklahoma City. And these records include the names of teachers, their salaries, names of the schools, and where they were located. And this concludes my Cherokee Moments for this morning.
Thanks, Mary Bale. Very
Thank
much
you.
appreciated.
Yeah, thank you.
Because the Cherokees always considered education of prime importance. And they still do, fortunately, particularly with all the scholarships that we award each year around the country. And if I remember correctly, the first superintendent of education was the Reverend Stephen Foreman,
Yes.
who led one of the detachments on the Trail of Tears. So, very good. Okay. Well, do we have any old business to cover? Okay. Well, very good. Oh, I will note that we lost one of our longtime Goingsnake members. Jimmy, I went blank on his last name, David, who died. Pardon?
Johnson.
Yes, Jimmy Johnson, who died in Claremore this last week. He was a good friend of Curtis's and was with Curtis at many events early on. He hasn't been present. Well, he used to come with Curtis at the Goingsnake meetings, but we haven't seen him for a few years, and his health hasn't been good for some time.
He had renewed his membership last year, Jack, so he was still a member. He just didn't participate in the Zoom meetings.
Right.
Do you know how old he was?
No, I don't.
I think I do. I think he was 82 or 83.
Okay, thank you.
He and his wife Charlotte went on some of our early bus trips back in the 90s. And then I think he may have gone on one or two without her also. Okay. Okay. And David, you want to reiterate when the Trail of Tears meeting is going to be?
Yeah, it'll be April the 23rd, Saturday, 10 o'clock at the Chodas Center in Tahlequah next to the casino. And Anita Finger-Smith from North Carolina is coming to speak about the genesis of the Eastern Band. So hopefully we'll have a good crowd there.
So, okay. So we should you should consider sometime in the future to see about when you have those speakers, have a Zoom meeting at the same time, or else record it and put it on YouTube.
That would be great.
I'm going to talk to the guy that I deal with at the Chodas Center and see if that's going to be possible for this time. I'll probably see him this next week and see what possibilities we might have to do that for this meeting.
Okay, good. Okay. Well, since I didn't line up an official speaker, which is why we also need help with that, then I was going to cover some things that Mike Wren and we were back at the Tennessee State Library and Archives last week and had lunch with the lady who's in charge of digitizing records. Well, it's more than that because she has the conservatory of records under her and a lot of other things that she supervises, but she's over that digitization project. And there's a lot of loose 1838 and 1842 claims papers that they have, as well as ones that are in books. Well, right now they have gone through and digitized all they have of the 38 loose claims and the 42 loose claims. They haven't done the books yet. But she's going to be putting all of those online at their Tennessee State Library and Archives website soon. So we'll let you know when that happens. So it'll be probably better copies than we have now. Plus, of course, we can replace on the Trail of Tears, National Trail of Tears Association website that has all the 1838 claims that we have located. Then we can replace her better copies, but that may be a while before we get that done. Because I think they're all still, the ones we have are all legible at this point, but we still want to have the better copies that she's doing for us. Because they have the majority of all the claims for 1838 and 1842, with a few scattered here and there. But another thing that Mike and I looked at were the Tennessee legislative acts and papers, which is their record group 60. And they're sort of a summary. Well, their acts, a lot of those don't have a lot of information in them but a lot of them do relate to Cherokees. But then there's a few that have reports on the acts, and one of those is from that did a report was from Hugh L. White, who was appointed to look at a lot of outstanding cases that had not been decided. And he was a U.S. Senator from Tennessee for many years, as well as several other important positions in the state. And he was a big Jackson supporter, and he helped get Jackson elected. But then he fell out with Jackson while he was president. So then he was anti-Jackson later on. So, but a lot of the cases that he had to decide were the cases about the reservations. So I was going to read a couple of the reports that Hugh White did. The one report, now this was all in 1827 that Hugh White was appointed, and he was trying to get rid of the backload of old cases. I'm trying to adjust my screen so I can see you all and still read from this. Sorry, I don't. Okay. Well, this is Templin W. Ross's lessee versus Manuel Parkinson. And it was the August term, 1827, in the Circuit Court of Knox County. It was on ejectment. So this suit was brought to recover 640 acres of land in the Hiwassee District, situated in the county of McMinn on Mill Creek. The plaintiff, which is Templin Ross, proved by James G. Williams that Ross registered himself with the agent for the Cherokee Indians for a reservation on the 9th day of August, 1819. That his wife is part Cherokee and stepdaughter of Major John Walker. That he lived with Walker and kept store for him in the year 1818. And that he has 4 or 5 children. And he said that Ross's father, Templin Ross, was originally from Pennsylvania, who was white, and not related to John and Lewis Ross family. It goes on to say that Ross's father lived in Georgetown, District of Columbia, and that he was at his father's the winter of making the Treaty of 1819. That the wife of Ross is the same Eliza Ross, to whom a reservation and fee simple of 640 acres of land is given in the 3rd article of the treaty made at Washington, 27th of February, 1819. So in the treaty, there was a huge number of people that received reservations. And it said, it's also, the 3rd article of the treaty is, it is also understood and agreed by the contracting parties that a reservation fee simple of 640 acres square, with the exception of Major Walker's, which is to be located as hereafter provided, to include their improvements, and which are to be as near the center thereof as possible, shall be made to each of the persons whose names are inscribed on the certified list annexed to this treaty, all of whom are believed to be persons of industry and capable of managing their property with discretion, and have, with few exceptions, made considerable improvements on the tracts reserved. The reservations are made on the condition that for whom they are intended shall notify in writing to the agent for the Cherokee Nation within 6 months after the ratification of the treaty that it is their intention to continue to reside permanently on the land reserved. So then it lists the people listed is Richard Walker in North Carolina, and also Yonah or Big Bear in North Carolina. Then in Georgia was John Martin, Peter Lynch, Daniel Davis, George Paris, and Walter Scott Adair. In Alabama, we had Thomas Wilson, Richard Riley, James Riley, Edward Gunner, Robert McLemore, who's in Tennessee, and then these others are Tennessee, which is John Baldridge, Lewis Ross, Fox Taylor, Richard Timberlake, David Fields, James Brown, William Brown, John Brown, Elizabeth Lowry, George Lowry, John Benge, Mrs. Eliza Pack, John Walker Sr., John Walker Jr., Richard Taylor, John McIntosh, James Starr, Samuel Parks, and the Old Bar. So, but he goes on. So James Nicholson proved that Ross once lived on the land in dispute, that the reason he removed thereupon was because his wife was in the family way, and he was desired she should be confined at her stepfather's. And John W. Blankenship proved that in the year 1820, Ross demanded possession of the land, that he then lived at Major Walker's, and that a man called Conley agreed to become tenant of the land. And Robert Murphy proved that he knew the place. First, he became acquainted with Ross in 1819 and never saw him in possession of the premises, but saw an Indian woman and some Negroes there in that year. The defendant admitted he was in possession of the premises in dispute, and the plaintiff, which is Ross, admitted that the defendant had purchased them at the land sales in the year 1820. Well, in 1820, Tennessee sold the lands that had been ceded without regard to the reservations that had been provided. So the defendant had purchased them at this land sale. The defendant then proved by Archibald R. Turk, Robert Porter, George Colville, and Joseph Turk that at the dates of the treaties of 1817 and 1819, Ross did not reside upon the ceded territory, but on the southwest side of the Hiwassee River, and after he took possession of the land in dispute, he removed away voluntarily from it. For the defendant, it was objected the plaintiff could not recover. First, because at the date of the treaty, Ross was a citizen of the United States, therefore not the head of an Indian family within the meaning of the treaties. Second, that he did not reside in the ceded territory at the time of either treaty and therefore not entitled. Third, that Ross's wife had a grant in fee of another tract by the third article of the Treaty of 1819, therefore Ross could not take a reservation of this tract. And switching pages, and I have to reduce the size before I can switch pages, and I increase it so I can read it better. Fourth, that Ross had voluntarily removed from the land and thereby forfeited his right to it, if any, or excuse me, forfeited his right to it, if any he had. So the court, which is Hugh White, instructed the jury that if they found the facts to be as the defendant's counsel supposed they were, that the law was with the defendant upon each of the points made. And so the jury found a verdict for the defendant. The plaintiff moved for a new trial, which was refused, and the decision acquiesced in, which is respectfully submitted, U.S. White. So I think the judge may have been leaning a little bit in favor of the defendant there. Okay, next. There are other cases that he's summarizing. But there's Gideon Morgan, lessee, as Philo versus Philo Fowler, or Philo, excuse me, Philo Fowler. It's also a jackment. So this is okay. This is Gideon Morgan, lessee versus Philo Fowler, jackman. This was an action brought by the title of 640 acres of land in the Wassee District, situated in the county of Monroe on the southwest side of the Little Tennessee River, the mouth of Citico Creek. The plaintiff, which is Gideon Morgan, proved by James G. Williams that he registered himself with the agent of the Cherokee Indians for reservation on the 21st day of July, 1819. The original registry, as well as a copy thereof, was produced, proved, and read. Williams further proved that he saw Morgan and his wife at the old agency, where Morgan had his store during the time of the treaty made in July 1817. Now, Gideon Morgan's wife and Templin Ross's wife were sisters. John Lowry, Esquire. So this is John Lowry, Esquire, meaning he was an attorney. There was a white man, John Lowry, in the Cherokee Nation that often gets confused with the Cherokee John Lowry because they were there at the same time. John Lowry, Esquire, proved that he was present at the marriage of Morgan and his wife sometime before either treaty, that Morgan's wife is, as he believes, a native of the Cherokee Nation and the stepdaughter of Major John Walker, that the marriage ceremony was performed by John McGee, Esquire, a justice of the peace for the county of Blount, that Morgan had goods of the nation before his marriage. At the time of Jackson's treaty, he lived and kept a store at the old agency. He was considered by the Indians as one of their people, met with them in council, was instrumental in procuring a deputation in the Indians to send a deputation to Washington City for the purpose of making the Treaty of 1819. He went along as one of said deputation, and is the same Gideon Morgan who signed said Treaty of 1819, which was done in February in Washington, D.C. And he is one of the signers. And which entered into, who was very instrumental, that when the deputation set out for Washington, Morgan removed his family to Knoxville, where he left them till his return, and where they remained till he removed to the land in dispute in the latter part of the fall or early part of the winter of 1819. That during Morgan's residence in the nation, he was frequently in the state of Tennessee, where he had valuable property, and when in the white settlements, he always exercised and enjoyed all the privileges of a citizen of the states. Witness believes Morgan had not any improvement, where he took his reservation earlier than the month of August 1819, at which time he began to improve the place and continued said improvements till his removal and for some time afterwards. That the place at the old agency where Morgan lived at the Treaty of 1817 is included in a reservation in fee simple for 640 acres given to Lewis Ross by the said Treaty of 1819. And that the same Margaret Morgan, to whom 640 acres are given in fee simple in the third article of the Treaty of 1819, is the wife of said Morgan. So here it is that Gideon Morgan and Templin Ross were both wanting to get reservations, and yet they're separate from their wives who had already both received reservations in fee simple. Calvin Morgan proved that he thought the plaintiff removed to Citico, the place in dispute, in December 1819. And this Citico, where Citico flows into Little Tennessee, is just upstream from the town of Shota. So, excuse me, Calvin Morgan proved that he thought the plaintiff removed the Citico of the place of dispute in December 1819, that he is charged on the 14th of that month on the books of GR and R. Morgan with goods for a store. That the plaintiff was concerned with him and was concerned with him and Rufus Morgan in the store, which means he was a partner with Gideon and Rufus Morgan in the store in Knoxville, and that there's never been any formal disposition of the partnership of C, G, and R Morgan to this day. That's Calvin, Gideon, and Rufus Morgan. That the plaintiff owned some valuable real property in and adjoining Knoxville. That when he first went to the nation, he supposed that it was to sell goods and to make money, and that he was in partnership in the nation with Major John Walker. On the part of Philo Fowler, it was admitted he was in possession of the land in dispute, and it was stated by Hugh S. White, who's the judge, and admitted by the plaintiff's counsel that at the land sales in 1820, he became the purchaser of the 640 acres now in dispute, that although the purchase and certificates are in his name, it was in truth for the use and benefit of the plaintiff, who then who then insisted he was entitled to the reservation which he now claims. That each portion of the purchase money, as has been paid to the state, was paid by the plaintiff. That the object of this suit was to have it fairly settled in a judicial tribunal whether the plaintiff was legally entitled to the said reservation under the treaties of 1817 and 1819. For the plaintiff, it was insisted that he was entitled to the reservation claimed both by the words and the true meaning of the 8th article of the Treaty of 1817, by the 2nd article of that of 1819. That he was a member of the Indian community recognized by the Indians, by the United States and the treaty itself as a chief or head man of the Cherokee Nation. He was therefore the head of an Indian family. His family were Indian because his wife was a native. He resided in the nation and on the ceded territory at the time of the treaty, had registered himself within the time and in the manner prescribed, and that his claim could not be defeated on the ground that he had no improvement of the place claimed at the date of the treaty, because improvement had been given to Lewis Ross, nor on the ground of the donation to his wife, because that must be viewed a gratuity to her, not affecting any right he might have under another article of the same treaty. On behalf of the defendant, it was contended, first, that the plaintiff was not the head of an Indian family within the meaning of the treaties, nor could be so except those who, by the registry, specified a wish to become citizens. Morgan was already a citizen and therefore could not, by registry, become one. That's a citizen of the U.S. Secondly, the only provision intended to be made for him or his family was the 640 granted in fee to his wife, and thirdly, that none could have a reservation who had not either a settlement or improvement the day of the treaty, because the reservation is to include the improvement. His Honor the judge instructed the jury that the two first objections taken for the defendant were fatal to the plaintiff's recovery, and if they believed the proof sustained either of them, the defendant was entitled to a verdict, but that he was inclined to the opinion that if all the objections were removed, the mere circumstance of the plaintiff not having a settlement or improvement on the land claimed would not prevent him from being entitled to a reservation. So the jury found a verdict for the defendant. The plaintiff moved for a new trial, which the court refused, and the plaintiff took an appeal in the nature of a writ of error to the Supreme Court, gave bond and security, etc., and the cause is thus in the Court of Appeals for decision, all of which is respectfully submitted by U.S. White. And we also copied that case in the Supreme Court records. So we have the largest Supreme Court case of that, which we'll have to get into at another time on it. But the records are there. And then another one that's kind of interesting is Nelson B. Grubs lessee versus John McClatchy in the Circuit Court for Knox County, August term 1827 on ejectment. So the Grubs are in the Grant family of Cherokees. So this was an action brought by the lessor of the plaintiff as the only surviving child of Allen B. Grubb, deceased, for the recovery of a reservation of 640 acres of land on the Wassee District, situated in the county of McMinn on Walker's Mill Creek. The plaintiff proved by James G. Williams that Allen B. Grubb, his father, entered himself with the agent of the Cherokee Indians for a reservation on the 22nd day of July, 1818, and described his reservation to lay southwest of the Hiwassee River on the South Mouse Creek. On the 17th of April, 1819, he again entered himself for a reservation and described it to lie on the Hiwassee River on the northeast side of the Clubfoot Bend. And on the 29th of June, 1819, again entered himself for a reservation to be on the creek 2 miles above Walker's Mill. The original registry and a copy thereof were produced. He also proved that the agency was moved to where it now is in the month of December, 1820. So it had been downriver a few miles, about halfway from the present town of Charleston to the mouth. So Joseph Turk, another witness, proved that he first saw the place down dispute on the 13th of July, 1819. That Grubb was then on it with four or five hands, living in a camp made partly with bark and partly with clapboards, having the appearance of one made that season. There was a foundation of a cabin laid and some rails split. The whole improvement had the appearance of having been newly made. Grubb's sons were there with him. He thinks Grubb left the place in 1820, and so did Cordial Davis and all those claiming under him. He thinks McClatchy got possession after the land sales in 1820. Siebert and Moore proved that he first became acquainted with Allen B. Grubb about Christmas 1819. He then lived on the land, and so did Grierson. Witness rented the land from Grubb for the year 1820. Grubb left the place early the year 1820 himself, and in the course of that year, witness Grierson and all Grubb's tenants and hands left the place. The reason he removed was because of a law which authorized the purchase of the land sales to be put in possession. Grubb had one of the houses on the place pulled down and hauled away. William Miller proved that he became acquainted with Grubb in November 1819. He then lived on the land in dispute, had his children living with him. His wife had died before he ever came to the place. Grubb continued to live there till spring 1820. He then moved to the other side of the Wassee, and his hands left the place after the land sales. William Smedley and Samuel Murphy proved in substance the same facts proved by Miller. Ambrose Agee proved that he went to the place with Joseph Turk and given substantially the same testimony with Turk. Robert Murphy proves that he first saw the place in the fall of 1819, was employed to make 1,800 rails on it, and done plowing for Grubb in 1820. Cordial lived and raised a crop there in 1820. Sam Davis there likewise. They and Grubb Negroes went away after the land sales. James Cowan proved that he had frequently saw Grubb before and became intimate with him in 1817. His wife died west of the Hiwassee, and he afterwards boarded with witness and with his father-in-law, Rogers. He built a house and taught school near the old agency in 1818. Then he moved to Hambrights or Clubfoot Bend, thence to the land in dispute. In 1820, moved to Pennsylvania, and returned in 1821, again boarded a while with the witness, then went and lived in Calhoun. In 1822, and Calhoun, of course, is just across the river from the agency present Charleston. In 1822, he built and settled southwest of the Hiwassee. He then went to Blount County and there died, and in 1823 or 1824, his corpse was brought to Calhoun where he was buried. His wife had 3 children to him. 2 of them are dead. She had a 4th to another man. It was admitted by the plaintiff that the defendant purchased the place in dispute at the land sales in 1820. Archibald Arthur, witness for defendant, proved that Grubb told him he had enrolled himself as an immigrant to Arkansas, drawn presents to which he was entitled. That was certain items they were given to the people enrolling for Arkansas, and had sent some of his property to Arkansas. That he'd afterwards taken a reservation, but he imagined he had conducted in such a manner as not to be entitled to one, removed from the place in dispute and settled in the nation south of the Hiwassee, and died in the county of Blount. George Colville, another witness, gave evidence going to prove some points with the last witness. To the plaintiff's recovery, it was objected by the defendant's counsel, first, that by the 8th article of the Treaty of 1817, the 2nd article of that of 1819, children have nothing but a contingent remainder during the lifetime of their father in the reservation. Second, that Grubb, by removing, forfeited his own estate and defeated the contingent remainder to his children. And that at the date of the Treaty of 1819, Grubb lived at the Clubfoot Bend, and if entitled to a reservation, it was at that place only. Fourth, that he had enrolled as an immigrant to Arkansas and therefore not entitled to one anywhere. The court charged the jury that if they were satisfied from the testimony that the facts were as the defendant's counsel had an argument supposed them to be, the law was with the defendants on each of the points stated. The jury found a verdict for the defendant. The plaintiff moved for a new trial, which was refused, and the plaintiff took an appeal in the nature of a writ of error, gave bond and security, and removed the cause to the Supreme Court of Errors and Appeals, all of which is respectfully submitted to U.S. White. And I see that Mike Wren has joined us. So Mike, do you have Anything to add about these records?
They're overwhelming. That's the best way you can put it. There's more stuff than you can get your head around. And we've probably only tapped about, I would say 2/3 of it so far. More Supreme Court cases we haven't gotten. Probably more legislative petitions than we've gotten so far. I don't know if you talked about those. And legislative records, there's still even more. So and every time you find something, it in your head, you go, oh, I need to look at the county record to see if there's something there that backs this up. Or so it's really kind of hard. Jack did it. I enjoyed it because I hadn't had a chance to read all the case files yet, like Jack has. There's one of them. It talked about, and I think it was Paintown. It gives a description of Paintown. It gives a description of the defenses, a fence around it. It gives a description of a hill and the townhouse sitting on top of a hill, which is not a lot of detail you get in a lot of records. And it was a casual comment by one of the witnesses in the case. So I've kind of flagged it in my brain, but I haven't had a chance to go back and get it and write, transcribe it down and send to an archaeologist to let them kind of compare it to any archaeological records that have been done. Just unbelievable detail in these cases. In the legislative records, it's the same. Some stuff is of minimal use, but even the stuff that you think is of minimal use still will point you to something else that you hadn't thought about. I'm trying to think of one that I might be able to pull up. Jack mentioned Hugh Lawson White was the judge he was talking about, and he was a political enemy, for lack of even, it's a truthful statement, of Andrew Jackson. So
But
Jackson said, go ahead.
Yeah, I had mentioned earlier, Mike, maybe before you got on, he actually supported Jackson in his election for president, and it was during the presidency that he had a falling out with him.
Yeah. And he gave a report, produced several reports for Tennessee legislature, and he gave recaps on all the lawsuits. Here's one for Mink Watts lessee versus Samuel Weir. Wendy Riley's lessee versus Uriah Allison. John Spears lessee versus Lewis Ross. Stars lessee versus Lewis Ross. The lessees of Kalinuski and Sonati versus Nancy Kennedy. Jack may not have mentioned this. This file, this Supreme Court case file itself, which we have, gives maybe 3 different generations of this family. Their mother was named Wally. They were siblings. There was another sibling named Kalinuski. Several of these people were dead, and it named their children. So lots of family information in some of these. West and West wife versus Charles Donahue. There was a case, but I hadn't been able to find it. But it did say that they lived at Tomotley and previously lived at Tellico Plains. Here's Path Killer. Maryville, I think we found 7 different Supreme Court cases involving his reservation. And don't have
That's
all,
amazing.
and some of them are huge, 150
That's
pages.
amazing.
How many records were created?
I know years ago, Jack gave me quite a lengthy one of the court cases, and it was a rather lengthy document. But do you remember that, Jack?
Yes.
And that's been quite a few years ago that you gave me that.
Well, we have more to send to you now.
Oh, good. I'll glad they receive it. Thank you.
Because Marybelle is the Path Killer descendant, in case
Yes.
you figured that out.
Yes.
This was one of the first cases he refers to here as Wiley Tootin's lessee versus Samuel Martin. And in the testimony of this case, it talks his Wiley Tootin's wife was Nancy Cootie. I remember that correct, Jack?
Yes, I think so. Yes.
And her mother, her father was Arthur Cootie or Archibald Cootie, I'm not sure, gave different names, and said that his mother was a white woman and that she was the sister of Samuel Riley, a white man, who I think, or Richard Riley, Samuel Riley, who was the interpreter for the Cherokee Nation. I don't think anybody ever knew that Samuel Riley had a sister who was in the Cherokee Nation. And these are just kind of off-the-cuff comments people are making in the testimony. Here's John Spears' lessee versus Benjamin Bond. Lewis Ross's lessee versus the Gambles. Mouse Payne's lessee versus Samuel McConnell and others.
And Mouse Payne is the one who lived at Payne's Town.
At Paintown, yeah. And there are case after case after case after case.
Wow.
Some of them we found, some of them we haven't. A lot of times the Cherokees themselves are not necessarily a party to this, but it's about the reservation. So everything about them kind of ends up in the record. Now, you know, when you look in a county court minute book, it'll simply give you the details of what happened. You know, it was delayed for 2 or 3 days, or the jury, they heard the evidence and the jury found them guilty or not guilty. That's about all you really get in a county book. These are page after page after page of testimony of sometimes it's, you know, the whites who were squatting on the land who gave testimony. Sometimes it's the people who were had bought a ride for the tenants of Cherokee. But it's full of information, full of details about specific locations, and as Jack said earlier, Walker's Mill Creek. Details you might not necessarily find anywhere else, but they're in these files. And this is part of the legislative record. So these things were part of a report that Hugh Lawson White did and presented to the legislature. There were 2 or 3 of these. So, and we really hadn't even had a chance to kind of process the information, and, you know, other than it sits in your head, I need to look at this closer. You know, where do you go next? Where else can you find something else? Sometimes all of these names, you can follow those names of the whites and particularly the perpetrators who displaced them, and then go look in deed records. And you may be able to really get down to placing, if you can't do it otherwise, placing exactly where a specific Cherokee lived at a point in time. I'll send this back to you, Luke.
So can I just ask, how many of these are there? Like what?
How many? Well, Jack.
Actually, Mike, they can go on the Tennessee State Library and Archives website, right?
Yeah.
And there's a finding aid. This one is record group 60. And doesn't it list all the?
Yeah, record group 60. It's this is Tennessee Legislative Records. And it's an online database. You type in a word. Now, the problem that you always get is the results you get come with the word you put in to search for. So if you if they have misspelled a name, it's not going to have artificial intelligence and figure out that they misspelled it wrong or you misspelled it wrong. So you kind of got to get creative and spell things as many different ways as you can. But a lot of times you can find stuff. You know, we did built an initial list based off looking for Cherokee, Reserve, Reservation, Indian. But a lot of times, once you do that, then you get names. I'm actually working on a list for a future trip, dealing with the Unicoi Turnpike and looking for, so I found different names, and I searched for individual names and individual spellings of names and found several petitions. There is online, they also have Tennessee legislative petitions. Let me look at that real quick and go back. Those are not necessarily as in-depth. But still they're a part of it. And there's separate finding agent Tennessee legislative petitions. The legislative records include original bills, rejected bills, approved bills, reports, correspondence, kind of any other record that really was created by, for, or about the legislator or part of the legislative process. The petitions were from individuals to the legislature, so they're part of a different record group. But there are all kind of stuff in the legislative petitions about Cherokee that you just don't find very much about. You can Google search for Tennessee Supreme Court case files. They have a interface on the, tell you what, Luke, let me see if I can do that, pull that up, and I'll show how to kind of search on it.
And I might add, if you go to the Tennessee State Library and Archives, y'all are driving through there, aren't you, Andy? They're extremely helpful.
Yes.
I don't know if you have time on your trip to stop and visit, but they're very, very nice there.
Yeah. We may tell them we're coming and see.
Yeah.
Oh.
So they were the holder of the largest amount of the 1838 claims. And they partnered with us and allowed the Trail Tiers Association to put those online. If you're seeing the interface now that says Tennessee Supreme Court case files, you can pick a particular county. You can pick a particular range of years. So if you wanted to say 1825 to 1830, you wanted to look for anything that said mentioned Cherokee. So it came up with 5 cases. Now I believe we have all of these already. But you're limited to only things where the word Cherokee has been abstracted by the Tennessee Archives and added to the case description. So if they don't recognize, the name John Walker as Cherokee, it wouldn't necessarily come up. So I said, just like anything, you've got to search fairly extensively.
Why don't you try Path Killer?
Try Path Killer. So Path Killer, spelled with no space in the middle, you get 2 cases. If you put a space in it, you don't get anything. But that was only let's say, I'm gonna go back 1800. Let's go to 1870 and search. So a lot of it has to do with any kind of limits you put on it. If I take all the limits off altogether, it's possible you might get more. Now, because I didn't put any brackets around this, I get anything that says the word path or the word killer. It didn't like that. So you can do path plus killer. Plus killer. So every one of these cases involves the same reservation.
Hmm.
74 pages, 70 pages, 56 pages, 114 pages, 160
Wow.
pages, 36 pages, 156 pages.
Oh my goodness.
Yeah.
We don't have all of those, but did we get them all? But was there one we was?
I think there was one of the large ones. Maybe it was a 114 page one. That one, I can't remember.
Because we ran out of time, Mary.
Ran out of time.
Oh, did you?
Yeah.
Wow, this
One of these
this is-
large ones. Excuse me. Go ahead.
this is amazing.
Yeah. Now, you can filter this down to a county. So Blount County, I figured out, didn't have any court records until 1850. So if you want to say, I want to look at, because I think my Cherokee ancestors were at Blount County at one point in time, and you want to look at it between 1870 and 1855, just to see what's there. They have 3 pages of court. So even though the county records don't exist at all, there are still other things. Now, one of the things that we were doing as we were doing this is paying attention to the names of the white people involved in the lawsuits and trying to look at any other cases they may have been involved in. Because sometimes the things you see here in the explanations, you just got some intern or some, low-level employee who went in and took some notes. So it may not, so you've kind of got to take some time to look at this, and they come up in reverse order. So here is, and this is, I think, Jack, this is a lawsuit over the estate of the father of John Lowry, Esquire, who was a lawyer and a member of the Unicoi Turnpike Company.
Who was the white attorney living in?
Yeah, he was a white attorney. But there are all kind of, there are names that you'll pick up after you start doing this, and you see the same people listed over and over and over involved in this McClung. He's mentioned in lots of different cases. A lot of times the names and the cases don't really have anything to do with the underlying real parties. It may say so-and-so, let's see, or it simply may say John Den, which is a legal name for anonymity, but they don't name that. Particularly if you're researching Cherokee and you've got names of perpetrators, people who were named in a claim as having dispossessed an ancestor in Tennessee, or they stole stuff from them and you don't know, is this a real person? You can search that person's name and see if you want to learn more about him, you may be able to nail down a little bit closer where your ancestor lived. Here's a case, I don't know who this is, Henry Shields versus Samuel Walker. So if you were searching for Samuel Walker, you wouldn't necessarily get a hit if you spelled Samuel the way that you think it ought to be spelled. This name they have is Barely, McGee is Barkley. It's not E-L-E-Y, it's C-L-E-Y or C-L-A-Y. He shows up in lots of different records. So there's lots of and from a history standpoint, it's easy to anecdotally talk about how hard it was, how much bad stuff was done to them, how they were, but it's a different thing when you really start looking at records and you go, it's way worse than I thought. They were harassed much more than you expected. And you got, you don't even have to say it, you just start presenting evidence. This happened to them, and this happened to them, and this happened to them, and this happened to them. So you've got evidence, but also from a bigger tale about the history of the Cherokee. you can see exactly how they were harassed, you know, from an illegal standpoint and from unethical people using the legal system to harass them and displace. One of the things, I don't know, Jack, if you talked about that case involving Lewis Ross.
Yes, last month I mentioned it, and Shirley, you'll be particularly interested in this because we were able to take a larger piece of glass to cover it so that we could get a good copy, and we did get good copies of that Lewis Ross case, which was well over 100 pages. And I'd mentioned last month that it was where he was being sued for a $9,000 note. And this is the Supreme Court case was cited in the 1850s, and stating that that was for provisions provided on the trail, since Lewis Ross had the contract for providing the provisions for Cherokees once the Cherokees took over. Then John Ross and other members of the council signed an agreement, which actually is in this court case, and I've never seen the actual agreement before, the contract before with Lewis Ross. So that is in that court case too. But the guy Ross had given him money to purchase salt, coffee, and soap for the Cherokees. And part of it was to be left at the crossing of the Ohio River, the other at the crossing of the Mississippi River. And so then the guy came back and told Ross, yes, that he had done this. And so then Ross gave him a note for $9,000 to be paid whenever the accounts were settled with the U.S. government over the removal. Well, from the fact that he never bought any of these provisions, and they were not there. And surely you'll find this interesting. The other person or another person that Lewis Ross had to go and purchase all these provisions was Thomas Carmichael Heineman, who was Thomas C. Heineman and Lewis Ross were married to sisters.
Knew he was deeply involved in it.
Yes. So there's pages and pages, and I mean big, huge sheets of small writing of his testimony. And it's very, very enlightening on how the provisions were done. And that I've never seen anywhere before either. So that's
You
it.
still haven't run onto George Merle's name, have you?
Yes, he was one of the partners in.
What was Lewis Ross? Or Heineman?
There were several. Lewis Ross had various partners.
Yeah.
In that, and George Merle was one of them.
Okay.
And then Thomas C. Heineman was added as a partner a little bit later.
Right.
So Shirley, if you wanted to, you could go onto that Tennessee Supreme Court case index, put in the name Heineman, and see how many cases you can find where Heineman may be mentioned, even though I know he was in Alabama.
Yeah,
Jackson.
I did a whole thing on him, you know, because it was his son who was in Arkansas during the Civil War.
Yeah.
That family was something else, but anyway.
And well, he had another son who was with him who was only 13 at the time, whenever he was supplying the provisions.
Really?
And but he said in his testimony that that son was now deceased.
Yeah, he was the one that was killed by oh gosh, who's the great writer down in Alabama? Oh, come on. Yeah. It was his great grandfather killed Thomas Heineman's son in a duel. It was bizarre anyway.
But anyway, that court case has lots of information that we did not have about the trail and how the provisions were provided. And Hyman, for example, bought stuff directly from the farmers. And this other guy had sent someone ahead who didn't have authority, and they only made contracts with stores and merchandising establishments. So they were paying a lot higher price
Right.
than the others. So it's interesting on all of this.
Wow.
But anyway, I got sidetracked on that. Go
Oh,
ahead.
yeah.
Right.
Well,
Well, I would like to add that I've enjoyed this and its powers that be that I was able to even attend this meeting. But the names popping up, the Templeton Ross and Eliza and the Lowrys, that is all traced to my mother's side. So this is very, very interesting to me. And I appreciate every one of you for doing the research. You know, it's another stitch in our family history, you know, that I think that it brings it all together. You know, it's just something else. You know, I really appreciate that.
Well, one of our longtime members and a dear friend of mine is Clista Anderson, who is also a descendant of Templin and Eliza Ross.
Really? That's
And
good
she
to
lives
know.
in Warner now.
Oh,
And she's done lots of research.
I will have to connect.
Yes. And of course, there's the connection to Andy because she's from the Walkers and Rita.
Yeah.
So
Supreme Court papers, is that what they're under at
the Tennessee Supreme Court records
Tennessee Supreme Court records?
at the Tennessee State Library and Archives.
They're in the library, right?
Jack,
Yes.
thanks to you and Mike, I really appreciate all the research that you've done on this. This is very enlightening. I never knew anything like these documents and records existed. And thank you.
Well, we're glad that we were able to research it, but it's all due to Mike. Mike's the one who located them all. I didn't.
Wow.
My father used to say that even a blind squirrel can find an acorn every once in a while. You just keep looking. You don't take no for an answer, and you keep asking questions and asking questions, and all of a sudden I wouldn't call it a breakthrough. You try to think, where would things be? Where could you find them? What survived? What else might survive somewhere else? So let's just say I was the blind squirrel that day.
There's always stuff out there somewhere.
Somewhere, exactly. Shirley and I did just look, and there are at least 2 cases in the Tennessee Supreme Court records that mention Thomas C. Heinemann.
Yeah.
There were several deaths. He was one of a party.
I knew he had a lot of offices back in, I think, Alabama.
Yeah.
And then they were an interesting family.
Very.
Yeah, he lived in Tippah County, Mississippi.
Yeah.
I believe the town of Wilson, if I remember correctly.
Jack,
Anyway, it's his hometown.
There's a story in there on that family in that book that we wrote on Hunter's Home in the Cherokee Nation. I'm plugging it. But anyway, but there's a whole story in there where we talk about that family.
Okay.
The Heinemans.
Let's his testimony was given in the town of Ripley.
Yeah, yeah.
Tippah County.
That's where I think that's where they're buried.
Yes, that's where they lived, right. Yeah.
So
Okay.
at this point, if we find records that we're interested in, we'd either have to go there or we can order copies.
Wow.
See if we have them already.
Oh, okay, yeah.
Or, we don't know when we'll go back again,
Yeah.
but if you tell us and we have time, we'll copy them. And if they're
Okay.
useful for one person, they'll be used for other Cherokee.
Right. Yeah.
And where are you putting the copies?
We're probably going to make
Sequoia?
it available through the National Trail of Tears Association website.
Okay. Okay.
Now, one of the things that we're talking to the Tennessee State Library and Archives is for them to digitize all of their 1842 claims. And they have now done that for all the loose claims they have, but not yet started on the bound claims books. And if anybody's ever worked in the microfilm, the quality is inconsistent. Something
Bale knows that quite well.
I know that quite well, absolutely.
Yeah.
I guess I was a little ahead of my time
That's
back
okay.
in around 1992, around that time period.
You're still ahead of your time, Mary.
Still ahead.
I wish I was.
Well, I will tell you, Mary Bell, since there's nobody from the Tennessee State Library and Archives, we told them, said that some of that you couldn't even include some of the images that were so bad in the book. And the lady said, "Oh," I said, "No." And I said, when you, because I went through and index stuff. I said, there's gaps. I said, there are parts of a claim where you can look at it and say, okay, it starts, and then you look to the next image and you go, it's 2 or 3 numbers later.
Correct.
So
yeah.
I said, so the people who microfilm missed pages and nobody went back and checked. So that's kind of one, when you get down deep in the weeds of stuff, then you find out there should be other claims that aren't even built. Even if it was readable, you couldn't read it because they're not there. So they've committed to digitize all the pages and check for all the images. So
that'll be great.
Yeah. And then make those available online to view. So
Amazing. That's amazing. I think is a lot of it making relationships with people who have all these records and letting them know that, we're interested and we appreciate it. And, for those of us who aren't near Tennessee, we can't really, it's not feasible for us to just go and.
Well, when I first contacted the Tennessee State Library and Archives, I don't remember who I sent the email to, but I went online, I think to the director probably. And then I got the response back from this one lady who said that she'd been hired to digitize, and she'd been there at that point less than a year.
Wow.
But she said that she had never heard of those Cherokee records that I had mentioned, and that she was really glad to know about them because she wasn't aware that they had all of these Cherokee records.
Wow.
And like I said, she's just been super helpful ever since and wants to put as much Cherokee material online. And she was hired primarily to get a lot of their original records put online.
Well, back in 1990, when I first contacted the Tennessee State Library and Archives, I did everything by mail, and I received permission from them to print the claims, and they sent me a very nice letter giving permission, and they indicated in the letter that they were glad that these were going to be made available because they thought that they should be. And everyone was so nice. I mean, they were just extremely, very accommodating, and I really appreciate that.
Yeah.
Well, they were, I will say they're still that way, Mary Bell. They were, of all the archives I've gone to, they have been really some of the most helpful.
Wow.
They will go out of their way to help you. And I don't know if it's because they were originally a library, but they're not at all territorial.
Yeah.
Not condescending. I don't
Correct.
know many different members of the staff we met, but all of them, you ask them a question, if they don't know, they'll go find somebody who does know something about it. They'll give you, there are lots of the Supreme Court, if you check on your books called the legal reports, who report on legal cases. So I found some cases involving Cherokee there that there's no case file for. And one of the ladies, I just say, okay, next time I come, I want to talk to you about okay, how do I research those cases? What other records would there be that I could find out what happened with this case? And she wanted to tell me, and I said, no, I just want to ask you so you're thinking about it. We can discuss it next time. So, but they really do go out of their way there to help. Very accommodating, very helpful.
Yeah.
And Andy and Rita, if y'all decide you are going to stop by there,
Yeah.
they have the parking garage underneath on the basement level, and you pull it because they don't have any other outside parking unless you park on the street. But you pull in there and then tell them that you want to renew your card or whatever, and they will let you in, and then you go to the first floor and you get your card. And then you have to use a card to be able to get into the research room.
Wow.
Awesome.
But it's all very easy.
Yeah.
But that way they'll open the gate for you and you can go park your car and
Awesome.
all that.
One of the things that helped us was that because we met them the first time, they said, if you come back, let us know what you're going to want.
Right.
We emailed them a list. We want to look at all this stuff. So we showed up and it was all there ready for us. They had it all pulled ahead of time. So we didn't.
Carts just stacked full of boxes.
Carts.
That sounds like a plan. That sounds like we should let them know ahead of time that we're coming and
yeah, be as specific about what, that's why I said if you go on those indexes,
yep.
now some things are on microfilm and they pull those for you as well.
Awesome.
But they have lots of finding aids online, lots of PDFs of different collections that they have. There's lots of county microfilm that's not available on Family Search or another site. So it doesn't, I think that is county records on microfilm. They have a finding aid and you can do it by county. If you're specifically looking for one county you want to look at, and you can look at it, see what microfilm they have, and then compare to Family Search and say, okay, oh, this is not on Family Search, but it's the right time period. I want to look at it.
Right.
Have they digitalized, it's her name, Penelope Allen Williams? Isn't she the one that bought a lot of that stuff?
Oh, it's Penelope Allen Johnson.
Johnson, okay.
Yes.
Yeah, she purchased it from Robert Bruce Ross.
Right.
John Ross's grandson.
Right.
Then the sisters sold theirs to Thomas Gilcrease.
Yeah, right.
Evidently, that branch of the family wound up with all of the Cherokee National Archives and then sold them off.
Well, at least they're somewhere they can be gotten to.
Well, you're right, most of them, the majority of them.
Some of it we hadn't found yet.
Because Penelope Allen scattered a lot of them.
Yeah.
What, like where? Any idea?
Yeah, the University of Tennessee Library has several.
Okay.
Chattanooga Public Library has a handful, not very many.
University of Chattanooga has a few.
Yeah.
Relate to Brainerd Mission that she had. Gilcrease.
Yeah.
And we think she sold them to some individuals also.
Yeah, she sold some to individuals. She sold some to the DAR chapter in Walker County, Georgia. Gosh. She was, I think, came from a comfortably well-off family, but she wasn't, rolling in funds. So I think she sold stuff not because she necessarily wanted to, because she needed to.
Okay. Wow.
Financially to pay for the other stuff she bought.
I think there's a whole document showing where all that collection is.
Where?
Surely, I think I have a copy of it. If it's what I'm thinking of, I'll send it to you.
Oh wow, that'd be
I'd like to see that also.
I know exactly where it is if I have it. It's the Penelope Allen Johnson collection. and I put it in a binder and I know exactly where it is.
So I think that's probably the finding aid for the Tennessee State Library and Archives.
Oh,
Yeah, or the one for University of Tennessee Knoxville.
oh, but it wouldn't be where everything is.
Yeah.
Hmm.
There are multiple collections with her name on it,
Oh,
and she was active in all kinds of stuff.
wow. Yeah, so it might just be, yeah, it is. It's the Tennessee State Library and Archives. That's it.
Yeah.
Hmm.
Wow.
Darn.
I agree.
86 pages. Holy goodness. 86 pages just there.
Yeah. Yeah.
Hmm.
So the 1838 claims that are on the Trail of Tears national website, most of those came out of that collection at the Tennessee State Library Archives. That's where a lot of them were,
Gotcha.
biggest part of them. But there were others that are elsewhere.
5 other locations.
Yeah, I transcribed some of the 1838 claims in my quarterly that I published for 15 years. Occasionally, I would transcribe one of the claims and insert that in my quarterly.
I wish you still did your quarterly.
Well, old age made me quit. 15 years, I was ready to pull my hair out.
I learned a lot reading that, Mary Bell.
Yeah,
You
I know
taught
I
me
keep
all.
thinking that they're sort of obsolete now with everything, a lot being online. But I know a library is interested in having them if I would make them available again. I have everything that I could make them available again if I wanted to.
Now,
I have everything to do it with.
now David, with his new scanner, could scan all those and they could be searchable PDF files.
Yes. Yes, I was going to get back in touch with David, mentioned that to me. And I was going to get back in touch with him, but this illness has just, taken its toll and I can't do everything. But I thought that would really be good if I would, and I have the hard copy of each one of them. So that's 15 years times 4.
Wow.
Now, 16
They were published 4 times a year.
What was that called?
The Cherokee Tracer.
Wow.
The Huntington Beach Library has some of those.
Yes, they were at one time subscribers.
Mm-hmm.
So, Mike, if we want to find out what's all at the Huntington Library, we'll just ask Andy.
Yes. I volunteered there before the pandemic, so they had a little collection, a couple shelves. Yeah.
Yeah, but they have several original Cherokee records. I believe
Huntington Beach?
Yes.
No, the Huntington Library.
Oh, no, excuse me, the Huntington Library, not
Huntington
the
Library. Yeah.
Yeah.
I didn't think it was my little Huntington Beach
Oh.
Library. The Huntington Library.
What,
That's
Andy?
fascinating.
I will say, it's harder to say no to a person face to face than it is, in an email.
Well, and that's the thing, if there's things that we can do here,
Yeah.
I'll go, no problem.
Yeah.
Do you live near the Huntington Library?
Pasadena's not far, yeah.
Yeah.
I mean,
Years ago, I was in California on business, and this was not me, Mary Bell will remember this, Nut. I would go into what's called the National Union Catalog of Manuscript Collections.
Mm-hmm.
And I searched for Cherokee records. Whenever I traveled to a different state, I would always say Cherokee records in California. And there's some little liberal arts college in California, and they had some 1840s records of Cherokee. And it was a family from North Carolina who had, over the generations, ended up in California. And somebody left them to this little library. I called them up when I was out there and said I wanted to come look at them. Told her who I was, and I was with the Trail of Tears Association. And she said, well, I'll just copy them all and I'll mail them to you. You don't even have to come to me. So it was a nice big pack. There were merchants in North Carolina, and made a scan of them and sent them to Brett Riggs, so they had them for North
Yeah.
Carolina.
One of the most important sources for research is the National Union Catalog of Manuscript Collections.
Yeah,
I've never heard of
It's
that.
essential.
essential.
Yeah,
Yeah,
I used that well,
not as
60 years ago.
Yeah.
Okay. Okay. Well, our time's getting short, and I appreciate everyone's participation, and